And is it Millen?
Yes, Your Honor.
Okay, if you'd like to go ahead then and present on that motion.
So yes, good afternoon, Your Honor. We did file this motion to designate Ms. Irma Rivera back in April 2024. This lawsuit arises out of a motor vehicle accident. At the time of the accident, plaintiff was operating a vehicle owned by Ms. Rivera. Ms. Rivera did entrust her vehicle to the plaintiff, who was unlicensed, incompetent, and a reckless driver. My client, the defendant, alleges that the plaintiff was negligent at the time of the accident because they ran a red light and they were speeding. They failed to keep a proper lookout. So we believe that Ms. Rivera should be designated a responsible third party in this case. The Plaintiff's Counsel did file a response January 21st, 2025, which is approximately 9 months after we filed this motion. According to the Texas Civil Practices and Remedies Code, Section 33.004, it states that if a party does not object to the motion to designate a responsible third party within 15 days, then the court must grant the motion. Therefore, we believe that plaintiff's response should not be considered and that this motion should be granted.
All right, thank you, Ms. Millen. Mr. Hill.
All right, thanks, Your Honor. This is a he said, she said swearing match at a light. Got a plaintiff and a defendant, neither of which have driver's licenses, both of which own their own vehicles. Been pretty straightforward from the start. We didn't object to any kind of timing on this. The motion to designate responsible third party was filed late. Like she said, it wasn't filed till April, but I didn't want to get into that. What we really need to get into is what we get into, even if we never objected, which is what the law says. And so the defendant's under I don't know if you want to call it misunderstanding, but they think that the plaintiff's sister owns the car, but there's literally no proof of that whatsoever. I mean, it's just them saying it. We filed a response because I tried to figure out where they got this from. And the closest thing that we have to it is the plaintiff's deposition. The plaintiff came from Guatemala, and when he first got here, he didn't have the ability to try to get a car in his name, to have a vehicle, and so his sister helped him get the car. There's case law on this issue. So the car initially went under the sister's name, according to the testimony. We've looked, there's no title to this vehicle. But even if there was, it would only create a rebuttable presumption about the ownership of the vehicle. So we cited all this. First off, I gave the court the deposition testimony where the defendant may have gotten this from. And in that, the plaintiff specifically says the question was, who was the titled owner of that car? The answer says, that car was under my sister's name because I had just arrived, but I was making the payments to the dealership, but it was mine because I was making the payments. And then there's other questions about if they live together. It goes through it. It says that they don't live together. His sister Irma lives on her own. He lives on his own. She has her own car. All right. Then we get into the case law. And according to the law, this is what it says. For the purposes of a negligent entrustment case, the owner of a vehicle can be, 1, a person or entity claiming ownership and having possession, or 2, someone who exercises control over the vehicle. We know that there's zero evidence that the sister exercises any control over the vehicle. And we know that there's zero evidence of a title. The next case I'll show the court, Dean v. Lowry, says specifically a certificate of title is not conclusive evidence of ownership, but it does create a rebuttable presumption that the named owner is the actual owner of the vehicle. And the presumption was rebutted in that case when the title was in the name of the driver's father, but the driver bought the car when he was 16. Kind of like the plaintiff in this case couldn't put something in his name. We continue on. There's another example from a case. This is Rush v. Smitherman. Loaning money to another to purchase a vehicle does not give the creditor the right to control the vehicle unless there's evidence that the debtor defaulted on the loan and the creditor had a right to repossess the vehicle. There's no evidence that anyone gave the plaintiff any money here. There's no evidence that anyone has sought the vehicle from the plaintiff, including the dealership or the sister. Another case, we continue on, it says ownership can be established by proof of the owner's liability insurance. In this case, we've turned over proof of the liability insurance card. We attached it to the response as exhibit number 2. We also attached the police report. The certified police report shows that the plaintiff was the owner of the vehicle. So with the case law, with the facts, there's literally only evidence that the plaintiff owns his own vehicle. And this is what we've been trying to communicate to the defense counsel since they first filed this motion back in April 4th when it was untimely. Now, Ms. Milan is new to the case. I'm going to give her some benefit of the doubt. She's been busy, but before her, there was a different attorney on it. Before him, there was a different attorney on it. I've just tried to take my time, be patient with this, because it's a silly he said, she said wreck. It was a bad wreck, but it's silly to try to blame someone who didn't even own the car. It has nothing to do with this wreck. Just a sister who helped a brother with a transaction at the very beginning of the case. They don't even live together. So that's the evidence. That's the law, Your Honor. We just asked the court, obviously, to deny it. And if the court were under the inclination that this is just a late objection, at some point we'd be back for another hearing to strike the designation anyway.
Right. Ms. Milan, it's your requested relief, so I'm going to let you reply.
Your Honor, I believe we were going off the testimony of the plaintiff in this case. He did testify that he was driving the Honda Accord. He said it was, the title was under his sister's name. He said he had his sister's permission to drive the vehicle and that she knew that he was unlicensed at the time of the accident. And she did lend him the vehicle. But I believe that is it, Your Honor.
Why wouldn't that be enough, Mr. Hill? I mean, I agree. You'll be back here on if the issue gets sorted out. But if that's his testimony.
Well, here's the thing. It's not. He never said that he borrowed the car. There's no evidence that it was ever entrusted to him. If that was the evidence, then sure, it's enough for a designation and a second hearing on a motion to strike, arguing the same thing we're doing today.
Well, I'm reading what you included in
Right.
your response. Who was the titled owner of that car? That car was under my sister's name because I had just arrived, but I was making the payments.
Right.
And it's that same sister who you were living with, Irma. No, Irma lives on her own now because she has her little girls. He told me the car was in this.
Your Honor, and I do have, if I could share my screen, I do have that deposition transcript where he does say, yes, I did have my sister's permission to use the vehicle. The insurance was under my name. She knew I didn't have a driver's license. It's difficult to obtain a driver's license here, is what he said.
But the insurance is under his name.
Right. And we have that. I could share a screen. I copied it.
No, it's okay. I'm sure you're telling me the truth.
To get back to the court's original question, you say, well, why is that not enough? Even if it was the way that the defendant represented it in the deposition, which I'm looking at, that's not what it says. The case law literally says that that's not ownership. She doesn't have possession. She doesn't have control. There's not even a title out there. If there was a title that had anyone's name on it, I would have made it an exhibit. We looked. It doesn't come back as a title. If the defendant could find a title.
Yeah, no, I don't disagree with that. It's just that this is a different threshold at just responsible third party stage. And so there wasn't a timely objection to the motion to designate. I mean, if I had that would be one thing for me to do. But there's no objection to it. And based on, I guess what I want to do is look at one other thing.
Yeah, and I understand all that, Your Honor. I mean, typically it's something that, we would file objections, all that. We had conversations with the prior attorney about this. This was something so just silly that they filed, and we were like going to mediation. Nobody even cared about it. And so the way that we looked at it was, even if we ever have to go and argue it like we're doing today, let's just treat it like you can have your designation, and let's actually look at the law and see if we're going to strike it. Like if that was I would have stipulated and said, hey, listen, if you just want your low threshold pleading requirement to have your RTP designation over an objection or with an objection, have it. But then look at the case law, because for the sake judicial economy between the court, us. We're going to be back here again.
But no, I understand. And here we are. But the good thing is that I can grant her motion to designate responsible third party, and you guys can actually have a more meaningful conversation about whether this person needs to even be part of the remainder of the discovery in this case, or you even have to file a motion for summary judgment. So I'm going to do that. I'm going to grant the motion for responsible third party. I don't see a trial setting on this case. I don't think I see a docket control order. And so I'm kind of wondering where all that stuff is. So I'd rather you have some meaningful conversations about that and move this case along.
Okay, well, I just want to, I get it. And we're obviously going to have to call tomorrow, set a hearing to strike it. And if the court follows the law, it strikes the designation.
Mr. Hill, I've given a ruling that you can do whatever you would like to do tomorrow. If you want to file the motion to strike it tomorrow, then set up your summary judgment, give her the proper notice, get it done.
We understand, Your Honor. We were just trying to save everybody time. That was all.
Yeah, I appreciate that, but here we are. So, Ms. Milan, do I have your proposed order?
Yes, Your Honor. I did send it to that email. I can put it in the chat or send it again.
No. If you've sent it to, I've just not had a chance to go search for it myself, but I will find it and I will review it. And if I have any changes to it, I'll make them and get it entered for you today.
Thank you, Your Honor.
All right. You both are excused. Thank you so much.
All
I
right.
hope you're
Thanks.
safe in Houston.
We're great. Thanks, Your Honor.
Okay.
Have a